Mr. McLennan, before you sit down, we would like you at some point to explain to us the procedures that are followed or would be followed under the draft code for ascertaining the wishes of people affected.
Yes.
Yeah, I mean, not necessarily at the moment, but at some point.
I'll either do it in the course of these submissions or I'll do it in my reply time. I'm not sure I'll have all the detail right now, but I will address it.
And also, if somebody has ascertained that the person is consenting and therefore they're not deprived of their liberty, if a relative or friend disagrees with that or has a different impression of what the person wants, what is the mechanism whereby that can be challenged?
Yeah, I'll come back to that as well. I was going to deal next with Cheshire West and the Supreme Court decision in 2014. I was only going to look to the Court of Appeal judgment briefly in the what was P and Q, became Mig and Meg case, just to show the court 2 points. One's a slightly fuller presentation of the factual background. This is Lord Justice Wilson, later Lord Wilson's judgment.
H?
2842. That's the start of the judgment, the Court of Appeal. Presentation of the facts is at 2849, paragraph 7, for P, who becomes Megan in the Supreme Court. Has a learning disability at the lower end of the moderate range, at the upper end of the severe range, problems with sight, hearing, communication difficulty, has limited understanding. And then her sister, again, description of mental age there, disabilities at the high end of the moderate range, borders in the mild range, communication skills are better, language skills are a level higher than that indicated by the overall assessment, emotional understanding is quite sophisticated, problem with sight, unlike her sister, she's troubled in her mind, exhibits challenging behaviour, may have autistic traits, and the court then notes the impairment of the functioning of their minds renders both P and Q unable to make decisions for themselves in relation to anything other than the most trivial day-to-day aspects of their lives, so they lack capacity in relation to all matters relevant to these proceedings for the purpose of Section 2 of the Mental Capacity Act 2005. So incapacitous minors, both of them, and you can see the characteristics are described there. The circumstances for their care are set out at paragraph 14 and 15. So P, who is Megan in the Supreme Court, living in an excellent foster home, devoted to her foster mother, had her own bedroom, refused to keep her door open, door was never locked. I won't read through the rest of that. Her sister is in a specialist home for adolescents, one of 4 residents, not a care home. Again, the circumstances of her arrangements again are set out in some detail there. And I flag that because it's a slightly fuller account than appears in the Supreme Court judgment of their circumstances.
14F, we're told that he had never attempted to leave the home and had shown no wish to do so.
The second point I wanted to draw to the Court's attention from the Court of Appeal judgment is Lord Justice Wilson's judgment on page 2853 into 2854. There's a general discussion of the consequence of objecting or not objecting to living circumstances.
Which paragraph?
It begins at 24, my Lord, and probably picking it up at the top of 2854. So, discussions going on here about happiness and its relevance, and Lord Wilson's noting its relevance as to whether any deprivation is in her best interests under the Mental Capacity Act. The overlapping feature, which is relevant, is whether the person objects to the confinement which is imposed upon her. While accepting, of course, the objections of a person whose capacity will negate the subjective element, Mr. Gordon appears to submit that irrespective of her capacity, they are irrelevant to the objective element. I disagree. The Commission submits, by contrast, the existence of objections is relevant to the objective element. To that extent, I agree with it. Guardedly, it then proceeds to submit, however, that it's not necessarily true that the absence of objections is relevant to it. To that extent, I disagree with it. If a person objects to the confinement, the consequence will be conflict. At the very least, there will be arguments. She will suffer the stress of having her objections overruled. And then description of stork and the level of conflict there.
You rather skimmed over it, but presumably you disagree with what's said in paragraph 24, that whether the person is happy in... The issue discussed is whether the fact that P and Q were happy in their respective environments was relevant to inquiry into the objective element, and you would say it's relevant to the subjective element, would you?
Yes. And there's an...
So you would say that Lord Justice Wilson was wrong between A and B when he says that the person's happiness is not relevant to whether she's deprived of her liberty.
Yes, but he's right in what follows in terms of what one can take from this and where it becomes of importance to the analysis. So picking it up again at D, where he's discussing the Stork case and the level of conflict inherent in overruled objections, seems to be highly relevant to the objective element. Equally, however, the absence of objections generates an absence of conflict and thus a peaceful life. Seem to be capable of substantial relevance in the opposite direction. So wherever one places this, it's being placed here in the objective aspect of the analysis. What Lord Wilson's identifying correctly, we say, is the absence of objections is capable of substantial relevance to the deprivation of liberty analysis. Right, some debate about where one places that, but he's correct about that. And then he discusses a judgment of Mr. Justice Munby at the time in respect of a incapacitated stroke patient to similar effect. So you see this debate that we're having about where one places objections or lack of objections was live in Cheshire West at the Court of Appeal, and you'll see then it is features to a much less prominent extent in the Supreme Court analysis. So moving to that, you have the decision of this court beginning at 2927. And it's a 7 justice panel. The court ultimately divides 4-3 on the issue of principle. Lady Hale and Lord Sumption give the leading judgment. You'll see that beginning at 2936. So paragraph 1 captures the issue, which is the circumstances of an incapacitous patient and whether their living arrangements can amount to a deprivation of liberty. The binary dimension of the issue is identified there. Much turns on it. They either have the machinery of the Dawes procedures engaged or they do not. And then the last sentence of that paragraph is a theme that runs throughout this particular judgment about the need for universality in respect of the rights of all with respect to Article 5. Pass over some of the background materials and take the court to 2939, which is paragraph 8, picking up essentially post-HL, the Bournemouth case, and the introduction of the amendments to the Mental Capacity Act in 2007. You see that by letter C. So as a result of the Bournemouth decision in Strasbourg, with the amending legislation, deprivation of liberty is not permitted under the Act save in 3 circumstances. So the court of protection cases, those are the minors cases, or under the procedures in Schedule 1A, or A1 rather, and under Section 4B, which are the emergency provisions. And the focus, much of the discussion in this context has been Schedule A1 cases. The safeguards are noted as being apparently bewilderingly complex, paragraph 9. Paragraph 10, there's some commentary on the extent to which the authorisations under the Act have been used. You'll see at this juncture, the figures are in and around 10,000 per annum, and I've shown you earlier this morning we now have about 330,000 per annum. The scope of the authorisation process far exceeds what was in contemplation at that time in 2014. And then some observations about the slightly counterintuitive aspect of considering all of this to be a deprivation of liberty. And the top page 940, again, the judgment then records that these cases are a good illustration of the sort of benevolent living arrangements which many may find difficult to characterise as a deprivation of liberty. And then you will see discussion of the facts of Mig and Meg, so that's P and Q from the Court of Appeal. Confusingly, we have two P's in this case now, but probably the focus is on the Mig and Meg dimension, and I don't propose to rehearse the factual background again there. The circumstances of P are set out in paragraph 16 as a different kind of case. This is an incapacitated adult in 24-hour care, but in a supported living arrangement. You see that at paragraph 17. There's a reasonable degree of autonomy, but some concerns obviously about behaviour. So these are classic social care cases. They are living either with a foster parent in a residential home, in a home for adolescent children, or in a supported living facility for adults. So these are paradigm examples of social care accommodation. Paragraph 19, Hale addresses the source of law issue, which we discussed earlier today. This is about section 64.5. And drawing the analogy with section 2.1 of the Human Rights Act, which again we have discussed earlier. Notably, in paragraph 20, the judgment records there's no case in Strasbourg which concerns the type of placements with which we're here concerned. There have been several relevant decisions in Strasbourg since the judgments in the court below. Most important is probably Stanev in Bulgaria. We looked at that earlier. That's the Grand Chamber decision, which is then referred to. Paragraph 22, you'll see, identifies the objective and subjective element and italicises those. And again, the point we've already touched on, the additional nature of the subjective element, and the judgment refers that back to Stork. Then some discussion of some of the decisions we'd already talked about, Shuk Takurov, Stork and HL. Paragraphs 26 and 27 involve a comparative discussion, Stanev case and the HM Switzerland case. So you'll see here, we're reading this primarily for reference to the subjective element, and so the judgment looks at Stanev, and then just above letter G, notes the subjective element was met, because he could understand the situation and express his wish to leave. That set the case apart from HM Switzerland. And then HM Switzerland is discussed as a difficult case, not least because of the Swiss legislation. And paragraphs 46 and 47, which I've also already opened to the court, are discussed there. HL in the United Kingdom is discussed at 29, and again, reference to HM Switzerland being distinguished, and the judgment records just below E that it was also distinguished in 4 later cases. That's Stanev, DD, Kedzayor, and Mihailov's, all of the judgments I've taken the court to. It is right that those judgments didn't follow HM Switzerland, but there is an issue as to whether or not they were truly distinguished, because they were all cases about taking into account wishes and feelings where there was an objection, whereas HM Switzerland was taking them into account where there was agreement. Then there's a reference to Milhailov's. The court referred to it, that's HM Switzerland, not during its assessment of the objective element, but only during its assessment of the subjective element of consent. Again, that's correct, but that doesn't take the matter much further. Reference to Nielsen in Denmark. Which is distinguished on the basis that it's about substituted authority. And then a discussion at 31 of all of those cases above. So this is an analysis of the key cases which I've drawn the court to, noting again the lack of de jure capacity, letter D, in the Schut-Korev case. Noting he advanced objections. Subjective element of lack of consent was made out. The court took the same view in DD and in Kedzior. Thus appears to give some weight to the objections of a person who lacked legal capacity when deciding the subjective element was made out despite the consent of the person's legal guardian. But in Mihailov's, the court seems to have gone further. And this is on the, I've already shown the court this, the second care home placement. He had not raised any objections. The court concluded he tacitly agreed to stay there, thus not being deprived of his liberty. In contrast, HL had been deprived despite his compliance. So the Strasbourg case law is clear in some respects, but not in others, which again does sometimes raise an ULA-type question. Then it's noted that the court has not yet dealt with a case like these cases, where a person lacks both legal and factual capacity to decide their own placement, but isn't convinced to satisfaction. A placement not in a hospital or social care home, but in a small group or domestic setting, as close as possible to normal home life, and where the initial authorisation of that placement was by a court. So that's not been addressed.
But that initial authorisation, what would that have been?
Those are not care home or hospital cases, so you need a court order for the authorisation. That would be.
I think it says it was a court of protection.
Yeah, court of protection. Yeah. Court then, the judgment records the arguments. Again, some of this is significant. At top of 2947, paragraph 33, the first and most fundamental question is whether the concept is universal. So there's a long discussion here about universality, which I'm not going to take issue with any of that. Perhaps more significantly, the second question begins at 37. What is the essential character of a deprivation of liberty? This is 2948. Common ground that three components can be identified derived from Stork, confirmed in Stanev. And those are A, objective component, B, subjective, and C, state attribution or responsibility. And then this appears to be a conclusory sentence. Components B and C are not an issue here, but component A is. And that is, again, it's open to question. If component B is not an issue, why is it not an issue? Because if we're applying Stork, Stork identifies the subjective as an additional element. Now, it may be that what the court has in mind here is that these are incapacitous patients. Therefore, one can read across from the lack of legal capacity, complete absence of any capacity or any need to engage with the subjective element. But that's not what the Strasbourg jurisprudence has been saying, and that's not what's been happening in the cases that I've identified for you. So that's quite an important aspect of the majority judgment, essentially indicating that the court doesn't need to be troubled with issue B, the subjective element. Although you'll see as we go on, it does leak back in to the analysis as the court continues.
And also, it's perhaps notable that B is framed in terms of valid consent.
Yes.
Rather than simply consent.
Yes. there's a later interesting observation by Lord Kerr about what's meant by that, which I'll come back to. That sheds some light on this as well. Paragraph 38, a flag that this is a recording of the arguments, again, from counsel on behalf of the local authorities, and you'll note the issue of coercion is put in play at the last sentence or second last sentence. The presence or absence of coercion is also relevant. Thus, there's no single touchstone of what constitutes deprivation of liberty in this or any other context. That's the argument. But coercion was an issue for consideration by the court. It doesn't really go anywhere, ultimately. The discussion section begins on page 2950, paragraph 45. So the universality theme is the first question that's addressed at the start of 45. 46 goes into the more focused question about deprivation of liberty. Again, it must be the same for everyone. And then the rhetorical passage that's frequently quoted: if it be a deprivation of my liberty, be obliged to live in a particular place, subject to constant monitoring and control, only allowed out with close supervision, unable to move away without permission, even if such an opportunity became available, then it must also be a deprivation of the liberty of a disabled person. The fact that my living arrangements are comfortable and indeed make my life as enjoyable as it could possibly be should make no difference. A gilded cage is still a cage.
Well, that's all very well, but she doesn't address the case, for example, of a bedridden person who is physically incapable of leaving the hospital.
Yeah. And this analysis doesn't itself really engage with the question of positive or negative consent by the individual. This is looking at it without that factor in mind. But that's become an important passage that feeds into paragraph 48, and the rhetorical question is posed whether or not there is an acid test for the deprivation of liberty in these cases. Then there's a reference to Guzzardi and an expression of the court's or the judgment's view that they confidently predict it will be repeated once more. Guzzardi is always repeated because that's the sort of foundational principle that applies in all the cases. We could expect that to appear in all of those subsequent decisions, and it does. Then we'll move down to paragraph 50 to discern the reasoning here. So it's a reference to two of the intervening charities who in their intervention list the factors which they say developed as indicators of when there's a deprivation of liberty. Each list is clearly directed towards the test indicated above. The charities do not suggest this court should lay down a prescriptive list of criteria. Rather, we should indicate the test and those factors which are not relevant. Thus, they suggest the person's compliance or lack of objection is not relevant. The relevant normality of the placement, whatever the comparison made, is not relevant. And the reason or purpose behind a particular placement is also not relevant. For the reasons given above, I agree with that approach. So there's still something important out of that, as to whether or not there ought to be any consideration of compliance or lack of objection. And this part of the majority reasoning is that there shouldn't be. The analysis is then applied to the P and Q, Meg and Meg cases, paragraph 52. Paragraph 53 is an interesting section looking back to the H.L. Bournewood case and the lower court's concern.
Is there any discussion of the man, of his views as to whether he should be there or not?
Limited discussion on the facts, really, I think.
Paragraph 51, the heading is application in the case of P.
Yeah.
Yes.
But but I don't see anything there discussing whether he was expressed any wishes as to whether he was happy where he was or not.
I don't think there's any more in that, certainly in the Supreme Court judgment. I don't think there's anything else anywhere. No, there isn't really. Sorry, going back to P and Q, Meg and Meg, you have an expression of relating to the acid test again at 54. If the acid test is whether the person is under the complete supervision and control of those caring for her and is not free to leave the place where she lives, then the truth is that both Meg and Meg are being deprived of their liberty. So that's the articulation of the acid test, and that's what appears, for example, in the Northern Ireland Code of Practice, the extant one, the unrevised one. You will see that is identified as the key indicator for deprivation of liberty. Those.
Yes. I mean, you skipped over 49, and that was really where Lady Hill set up the acid test in the first 4 lines of 49.
Sorry. Yes. Yes, that's taken from HL. Yes. Paragraph 55 is, again, worthy of close consideration. This is looking at the 2 minors. The objections can be raised to the finding they're deprived of liberty. One is that neither could survive without this level of supervision and control. That's to resurrect a comparison with other people sharing their disabilities. Another is they're both content on their placements, with their placements, and have shown no desire to leave. That's tacit acceptance. If the tacit acceptance of the applicant was relevant in Mihailov's, why should the same tacit acceptance of Meg and Meg not be relevant too? I found this the most difficult aspect of the case, but Mihailov's was different because he had a level of de facto understanding which enabled him to express his objections to the first placement. Again, query whether or not, in fact, there isn't sufficient material in the presse of the facts in the Supreme Court judgment or in Lord Wilson's presse in the Court of Appeal to suggest that, in fact, for one or other or both, they were capable of a de facto level of understanding, allowing them to express objections. The judgment goes on at E. The Strasbourg Court accepts there are some people who are not capable of expressing a view either way, and this is probably the case with both Meg and Meg. Again, on one analysis, applying Mihailov's, these 2, or at least one of them, may well satisfy the tacit acceptance test. And in a reference to HL in the final section of that paragraph. In the end, none of the suggested distinctions is satisfactory, nor should they be. It's very easy to focus on the positive features of these placements for all 3 of the appellants. The local authorities responsible have no doubt done the best they could to make their lives as happy and fulfilled as well as safe as they could possibly be. But the purpose of Article 5 is to ensure that people are not deprived of their liberty without proper safeguards which secure the legal justifications, the constraints under are made out, and so forth. And then, just towards the end of that paragraph, if P, Meg and Meg were under the same constraints in the sort of situation in which Mr. Stanev was confined, that's the Article 3, breaching care home, we have no difficulty in deciding that they've been deprived of their liberty. In the end, it's the constraints that matter. Now, the difficulty with that analysis ultimately is that one asks rhetorically what, if any, weight's given to the subjective element and the possibility of valid consent expressed by way of tacit acceptance. And at one view, it looks like it's been ruled out back in the rejection of component B on paragraph 37. And so from that point on, that issue isn't given weight or appropriate consideration, and there is necessarily a focus on the constraints in the circumstances. We say that's where the analysis goes awry in the lead judgment in Cheshire West. And it is, we say, a required feature of the Article 5 Stork test. The additional element of valid consent is given some effect.
But in fairness to Lady Hill, in 55, she expresses the view that Meg and Meg were not capable of expressing a view.
Yes.
So the B test may not be relevant in that particular case.
Yeah, that's one of the difficulties. It's not immediately clear why the B test is not in play. We put forward various speculative scenarios. It may be that. It may be that there's a conclusion reached that lack of legal capacity means one leaves it out altogether. On the facts, it may have been considered not appropriate, but then on the facts, we say, even reading the press here, that there's an indication that there could be a finding in respect of tacit acceptance, and that would be the case applying Stork.
I see the difficulty, because if you go back to 48 and 49, you're told that the acid test for deprivation of liberty is the continuous supervision and control and not free to leave. So, yes, there is no focus in that articulation of the acid test of element B.
It could arguably come in there if we interpose it in the objective test. It's not there either. So it's not introduced in the objective test. The subjective test has been set aside. Accordingly, there is no space for consideration of valid consent on this analysis. We say that's...
But do you read that sentence in 55 at letter E as indicating that she wasn't necessarily assuming that because they had been determined as not having mental capacity vis-a-vis decisions as to their residence, then automatically they couldn't consent? She's applying a slightly more nuanced test.
Yeah, I think in fairness, it looks like there's a qualitative analysis going on there of their actual ability, and the probably points in that direction. So it's not simply reading across lack of MCA capacity to lack of capacity. But, the point that's often circled back to on the facts of these cases, I'll probably get the acronym wrong, is that Meg describes herself as happy. There are circumstances. I'll not be able to find exactly where it is,
But the point she makes in 56 is one doesn't know what is the cause and effect relationship between the fact that they are treated as deprived of their liberty and the very positive arrangements that have been made for them. That's why it's important to understand if those arrangements are not that if they are not treated as being deprived of their liberty, how is it determined what the best possible arrangements for them are, and what is the ability to challenge that?
yes, I mean that's a strong undercurrent in this judgment, is the need and the drive for safeguards, and that's not concealed at all, because if you go to the next page, paragraph 57, you'll see the heading policy, which puts that front and centre. So exactly that point writ large, the vulnerability of people like Meg. I believe we should err on the side of caution in deciding what constitutes a deprivation of liberty in their case.
Just before we get to that, can you help me with the last two sentences of paragraph 56? We're told if P, Meg and Meg were under the same constraints in the sort of institution in which Mr. Staneff was confined, we would have no difficulty in deciding that they had been deprived of their liberty. In the end, it is the constraints that matter. Well, I have some difficulty following the reasoning here. If it's the constraints that matter, and P, Meg and Meg are not under the same constraints as Mr. Staneff, then what does the conclusion reached in Mr. Staneff's case tell you of any assistance?
This goes to the gilded cage point, I think, that you still have constraints. These individuals are not in an Article 3 breaching basement. In fact, they look like they're in comfortable, high-quality surroundings. Yeah. Some of them are happy, they say. But the analysis here is, well, assume all of that's wrong, and we're in some post-Soviet care home with Article 3 standards being breached, then what would our view be then? I'm not sure that the analogy really works, ultimately. And nor does it necessarily follow that constraints, i.e. the objective element, are the only issue, because we know from everything we've seen before that they're not. There has to be consideration of the views of the individuals. So then 57, it's a clear steer that you have a drive to universality of rights, and that's threaded through this judgment, and then concerns about the policy impact and the value of having procedural safeguards for individuals in this context.
In P, from what we're told about P, he was subject to restraints. He had to be, because what he wanted to do was unsafe.
Yes.
So his case, an easier one perhaps than the two women.
Yes, the Meg and Meg are falling on the side of the line where it's really open to serious doubt whether properly so-called this is a deprivation of liberty as people understand it, and whether or not there's a necessary absence of consent to the placements. It doesn't seem that there is. But that's taken out of the equation because of the approach in the legal analysis.
So you accept that if somebody objects to their restrictions, then their subjective views have to be taken into account, even if what they would prefer to do would be very unsafe for them. They're still objecting, and that would still make it a deprivation of liberty,
Yes.
even though it's very much in their interests that their objections are overruled.
Yes, that must be right.
So that's probably as much as I want to show you about the Lady Hale, Lord Sumption, judgment Lord Sumption agrees with. Lord Neuberger follows, and this is commentary on all of the other judgments you'll see from paragraph 59, noting the issues are difficult and important, noting the dissenting views of Lord Carnwath, Lord Hodge, Lord Clark. And paragraph 60 again, noting the value in having authoritative guidance in this area. Paragraph 61 endorses the approach adopted in principle in the leading judgment. And then notes the objection that's raised in the minority judgments about parting company with the Strasbourg jurisprudence. 62 records that, again, it's correct. There's been no decision of the Strasbourg Court involving the combination of factors which are in the present cases. And then it's also true that the Strasbourg Court has highlighted every case as highly fact-sensitive, and noting the distinction between deprivation and restrictions, one of degree or intensity. Then you have 63, a presse of all of the key cases that I've already taken the court through, not really flagging the subjective dimension. It's really those cases insofar as they address the objective case. And then paragraph 64 is a debate or rebuttal of minority analysis. And you'll see at 64A, one of the points that's made is about the persons lacking capacity to decide in their place but have not evinced dissatisfaction with or objection to it. We'll trace that point. And you'll see that picked up at 67. As far as factor A is concerned, I consider it to be inappropriate to hold if certain conditions amount to deprivation of liberty. In the case of a person who had the capacity to object and did object, they may, or even worse, would not do so in the case of a person who lacked the capacity to object. And Lord Neuberger describes all of this as a recipe for uncertainty. Then it says the notion the absence of objection can justify what otherwise amount to deprivation is contrary to principle. It is true and indeed sensible that a person's consent, provided it's freely and properly given, may serve to defeat a contention she's been deprived of her liberty. However, it involves turning that principle on its head to say the absence of objection will justify what would otherwise be a deprivation of liberty, save in those rare circumstances where the absence of objection can be said to amount to consent. In Mihailov's.
What do you say about the middle sentence of 67? Do you say that there are some degrees of confinement which would amount to a deprivation of liberty even if the person seems to be happy with them? Or do you say wishes and feelings are only relevant where the confinement is a kind of borderline factual situation?
I think they have to be relevant generally, not just to the nature of the particular circumstances. So if we're giving effect to valid consent and wishes and feelings, then that's a factor we play into all of the cases. It's not necessarily affected by the nature of the confinement.
Lord Neuberger talks here about capacity to object, and we've explored that capacity is actually a slightly ambiguous term in this context. But, I mean, one could read paragraph 67 almost as eliminating the subjective element completely.
Yes. Which I think is...
Which probably means that that's what enables him to agree with the acid test by Lady Hale, but she's eliminated this as well.
That's how all of this works in our submission, is that the subjective element is taken out of the equation. We operate only an acid test, and that's how one gets to the ultimate conclusion.
Yeah.
We say that's a misstep in light of the Strasbourg jurisprudence.
I'm just looking back to paragraph 63. In citing Stork, he cites paragraph 73, but doesn't have a discussion of 74, and which is the relevant bit one.
And Stanev also, I think, the relevant paragraph in Stanev is 117, and the court cites 128. We could probably trace Mihailov's. I'm not sure if that's the right focus or not, but yes, you can see what's happening here is we've veered away from factor B, subjective element. We're looking primarily at factor A, objective element, and this issue is evaporating from the overall analysis.
But is that because it was common ground between the parties that a lack of legal capacity meant you couldn't consent, so the subjective element was out of bounds?
It may have been.
I'd read that somewhere, but I may have misremembered.
Again, it's one of those cases. I think it was. I'm not sure there was Secretary of State involvement in the Supreme Court. It probably wasn't. It was local authorities were arguing the case. I'm not sure.
I think the reference my lady has in mind may be paragraph 37 on page 2948.
Common ground.
Common ground, yes. That's why it's always better to argue.
I could tie that down by looking at the arguments that were made, but I haven't gone through them, but I wouldn't ask you to do that now.
Whether it's common ground or not, I suppose, going back to the task in hand, section 64.5 doesn't absolve anyone involved of analysing the historic tests, which is it's front and centre. It's in the cited authorities. It is there, but it doesn't feature. So paragraph 68, I think, is key to Lord Neuberger's analysis. I don't think I need to show you anything else out of his judgment. Lord Kerr's judgment begins at 2958. Agreeing with Lady Hale, Lord Neuberger. Paragraph 76 is interesting how it commences. While there is a subjective element in the exercise of ascertaining whether one's liberty has been restricted, this is to be determined primarily on an objective basis. Not sure where that proposition comes from. That our submission doesn't align with para 74 of Stork, which identifies it as an additional important element.
Which paragraph was that, sorry?
That's 76, in order to the top of 29.
Thank you very much.
Lord Kerr does deal with the subjective element directly, paragraph 81, 2959, and describes it as subjective element in deprivation of liberty is the absence of valid consent to the confinement in question. Para 117 of Stanev, that's exactly on point. That links to 74 of Stork and everything else. But it's a focus on the absence of consent. And the issue, certainly in the case we're dealing with now, is not the absence, it's the presence of consent, and whether or not that's a factor that should be given consideration. But if the absence of consent is relevant, then we say it follows, night follows day, that the presence should also be given weight. He says this must be distinguished from passive acquiescence to deprivation, particularly that stems from inability to appreciate the fact that one's liberty is being curtailed. At 82, benevolence is irrelevant. And then some discussion of HM Switzerland. Lord Kerr joins issue with the minority, paragraph 85. And this is on the application of the section 64.5 channel for ECHR jurisprudence. And Lord Kerr differs on that. You'll see that at the first sentence of 86. With respect, I do not agree that cautions the appropriate reaction in the absence of authoritative guidance from Strasbourg. Again, some further treatment of that. This probably doesn't align precisely with where this court is now on Re-AB from 2021, the current application of the other principle, but that's not critical to this case, but it's again a point of some difference. You'll see at paragraph 87 again a tilt towards the objective element. It's apparent the two central features of the current Strasbourg jurisprudence point clearly to the conclusions of deprivation of liberty in these cases. These are that the question of whether there has been a deprivation is to be answered primarily by reference to an objective standard. We say that doesn't necessarily follow from what I've shown you. And the subjective element of the test to be confined to the issue of whether there's been a valid and effective consent to the restriction of liberty. And is that he supports the majority. So that's the all four of the majority decisions. There's a dissent. The longer of the judgment is Lord Cormus and Lord Hodges from 2961 onwards. You'll note at paragraph 90, it's described as common ground. The approach contended for by Baroness Hale goes further than any existing European Court of Human Rights case law. And we say it doesn't align. That's, we say, clear. Paragraph 91 goes back to the source of law point we were discussing earlier today. Section 64.5 ties the concept of deprivation of liberty tightly to the Article 5.1 jurisprudence. So we're more closely tied, the judgment says, to its interpretation of the Convention than we are under Section 2.1. That's the point I was touching on earlier on. And then reference to Pinnock, paragraph 93. The mere fact that Strasbourg's not yet occasioned to consider a case with these factors doesn't preclude us from forming our own view. Then reference to Ambrose and Harris, which is looking for a clear indication. That's echoed in the AB jurisprudence in 2021. However, short of such a clear indication, we should be cautious of extending a concept of sensitive deprivation of liberty beyond the meaning it would be regarded as having an ordinary usage. Then paragraph 94, the attractions of the universal test are identified, but it's not a concept we can find reflected in the Strasbourg cases. The mirror principle tested and found not to apply, no reflection on that point. So you have then discussion of Stanev, which is the Grand Chamber decision. And I'll read through what follows. Paragraph 97 is backward looking at those cases, noting that they are largely institution cases, not in ordinary homes. There's no Strasbourg case in which the has been found in comparable situations to the circumstances of the present. And a number of cases contain pointers in the opposite direction. And those cases are Nielsen, HM Switzerland, HL in the United Kingdom, and Hayden in Germany. To that might have been added, of course, Mihailov's, perhaps the clearest indicator of that. Court then notes, or the judgment then notes, none of these cases are conclusive. But if we were to look for a clear indication of the matter, we're not persuaded they provide sufficient support for the general test. proposed, and concerned that nobody using ordinary language describe people living happily in a domestic setting as being deprived of their liberty. So that's the general principle discussion. Then the judgment deals with the facts of the cases, and I don't think I need to spend time on that. Lord Clark gives a separate judgment. This is the third of the minority, agrees with those conclusions. By letter E, notes that the Strasbourg Court has not held there is only one question or acid test, namely where the individual concerned is free to leave. That has to be right. There is no articulation of an acid test. That language doesn't appear anywhere in the Strasbourg jurisprudence. What we do have is the Stork test, which has not only one but three elements, subjective and objective, importantly for our purposes. Yeah, that's what it is. Lord Clark's judgment pulls very heavily from the lower court's factual consideration, and I think it's somewhere in this text that you'll find the description of Meg, I think, being happy with her circumstances. 234. Right, it's on 234, yes. Page 2967, the quoted paragraph 234. I've not met Mick or Meg. I've read much about them and heard much too. Their wishes and feelings are manifest and clearly expressed. They plainly have no subjective sense of confinement. In a non-legal sense, they have capacity consent to their placements. I cannot imagine that any person visiting Mick at the home of JW or Meg at B home would gain any sense of confinement or detention.
Sorry, that's 2967.
2967, yes.
Where?
Just it's an indented paragraph, a little bit up from the bottom of the page, 234, my lord.
Thank you.
I think this is a quote from the first instance.
First instance judgment, yes, it is. So, if we were applying...
Looking at little Roman 5, just under A at the top, neither is restrained, save for immediate purpose of ensuring safety, in the case of Meg for her immediate protection, and that of others when she has an outburst. Now, do you read that as saying that it's because the restraint is of a temporary nature, it doesn't amount to confinement, or is it saying because the restraint is for those purposes, then it doesn't amount to a confinement?
It's not obvious it's a confinement in terms of physical liberty, but whatever it is, it's reactive and short term. It's something that's done to deal with an episode rather than a permanent state. And this is Meg, I think, who is a sister who has got the slightly more challenging set of behaviours. So one can distinguish between the two of them if we really drill into the detail, but there are, I think the omnibus conclusion of 234 is important. They plainly have no subjective sense of confinement. If we were giving weight to factor B, as I say we should be doing, then that's of key importance in the deprivation of liberty. And Lord Clark, 108, explains why he set all of that out. It seems to set out the many relevant factors with clarity and demonstrate why the lower court was entitled to hold they were not deprived of their liberty. No reason to depart from that. Lord Cumberland and Lord Hodge agrees with that nobody using ordinary language describes living happily as being deprived of their liberty. So the happiness concept is there again. I'm not persuaded the European Court would so hold. So that's the minority reasoning. As I've indicated to you earlier, in the sequence, the Law Commission were considering all of these matters at the same time. They produced a report a week before this judgment came out. The impact of the judgment was very significant. And
sorry, just on the question of the temporary restriction while she has an outburst. I was just looking back at Ghazali, paragraph 92. So the criteria include type, duration, effects, and manner of implementation of the measure in question. So and it's said to be something of a sliding scale, so there would have been scope to take account of the fact that it was temporary, to say that's not a restriction.
Yes, but in fairness, in point 7 at page 2967, we've looked at point 5. Point 7 says, if either wished to leave in the immediate sense, each will be restrained or brought back to safety. Yeah. So they were confined to that extent.
Yes, that's right.
There's also a finding at the top of the previous page that if a local authority felt that either was actively unhappy while they were placed, then other arrangements would be made.
Yes, the same point is made in point 7.
Yes, but if we were operating in a regime as you wish it to be, then that question changes to be the question, if either of them became actively unhappy where they were placed, what is the mechanism for someone then reassessing whether they are consenting and deciding if they're not, then there is a deprivation of liberty. I mean, the local authority there is making that assessment and moving them because they are treated as being deprived of their liberty. Or perhaps I'm mistaken on that.
No.
But, I mean, that's all very well, but if you're saying that the fact that they're not actively unhappy means they're not deprived of their liberty, I'm not quite sure what the relevance of that statement is, because that situation wouldn't arise because they've been consenting until now.
Yes, expressing no view either way.
Yes.
It's only when the issue becomes live that there's a...
Yes, so what I want to hear from you is, if that issue becomes live in a context when they are treated under your guidance as not being deprived of their liberty, what then happens?
Yeah. We have something from Mr. Ruckkeem. We've set some of this out in our written case, page 68, in terms of a record of valid assent being subject to review. So
Yes, I know it says that. You write it down if they consent. Fair enough. But what kind of review are we talking about? But anyway, I don't want to take you out of your course, but just to reiterate that is something I would like to...
I think, well, speaking of myself anyway, part of the concern is it may well be social workers that are saying, no, they're perfectly happy, they're not objecting, where it's the social workers which are the ones, in a certain sense, subjecting them to the situation that they're in. So there's a certain sense in which they might be said to be judging their own cause. And how does that work? Is that how it works?
Well, that is the scenario that can arise, and there's a potential risk of people marking their own homework or whatever it happens.
Yes.
Describes it. That's a proper concern.
So you have to sort of rely on the professional standards of the social workers that they...
Other types of oversight, the RQA authorities or CQC, whoever supervises all of this, the policies and processes you put in place. This is not fully developed in the Northern Ireland context, partly because we've only got as far as a draft proposed code. There's no point in working all of this up if this is not lawful and done in the first instance. So we've set out paragraph 54 and following of our written case, that's page 68 and 69, the types of policies that can be engaged to address reviews here. There's also a dimension of this that can be addressed through care planning.
Well, yes, this is the kind of information I'm really struggling to understand. But if my parent or sibling is in a home and the social workers say, oh yes, she's very happy, she's always smiling, and I know when I see her that she's saying, "Get me out of here, it's horrible," how is that addressed?
We have a separate note which we can provide on the care planning process and how it works in the Northern Ireland context. You have one from the England and Wales perspective, I think, from the department. We can provide the same thing so the court can see the nuts and bolts of how this would work and whether or not it's a proper safeguard or efficacious. So we can give you chapter and verse on that if the court's prepared to accept it from us. We have it ready.
Suppose an issue did arise and the social worker, although they thought that they seemed happy enough, but a relative was saying no, they're not very happy. So an issue had been identified. Is there some mechanism to refer that to the official solicitor? Again, I think I'm in some ways repeating my lady's question. How would that sort of situation be worked through? Are you just left with the social worker in case saying, no, it's fine? Or is there some way that you can test it with an external body at that stage?
I don't have the detail off the top of my head, but we will.
Can you assist us at some stage,
At some stage
with that?
We'll let the point pass without coming back to that. But it may not be until our reply. Moving back to Cheshire West and the outcome of Cheshire West, it had an immediate impact, as you've seen. We've moved from 10,000 assessment cases a year to a great many more, almost overnight. There's a useful piece of text in Dr. Series' book at page 6237, if you have that. Under the heading Broken System, 6238, and describes the explosion in applications that followed, how supervisory bodies were completely overwhelmed, and the impact that had throughout the system. I won't read through all of that, but that's it.
But what point do you ask us to draw from this, that because there are so many people, it can't possibly be the right test? Or?
Well, it could be the right test, but the point we take you to draw from the legal analysis, it's the wrong test. And
then why do we have to refer to these figures?
You don't necessarily have to know, it's just a scale issue. Yeah. But what you see then is that what I wanted to show you was the policy response. And the policy response, or one of the possible policy responses, was to adopt exactly the model which the Minister for Health in Northern Ireland has put forward in this code. So, and I wanted to show you that the issue, if that is the true problem, the relegation of subjective test, can be addressed by the type of proposal that the Minister for Health has brought forward in this jurisdiction. So I'm just capturing the problem. The Law Commission...
And I think you can legitimately... I mean, we may not be in 1966 practice statement territory because of the statute. But if we are, then in deciding whether to... If we thought that the previous decision was wrong, in deciding whether to depart from it, it would be material to know that if it had caused practical problems.
Yes, so real practical problems.
Yes, well, I mean, part of the context to Cheshire West was a representation to the court by the appellants that going down the road that they advocated would only create some administrative work for local authorities, and it would not be a significant burden. And that turned out not to be the case.
That's recorded in Lady Hale's judgment, I think, that very point. So yes, that's right. Obviously, there are limits to a consequences argument or a consequential argument. It does have a bearing on what this court does with a decision of its own. I agree with that. It is the case across the United Kingdom jurisdictions that this has been identified as a problem, not just in Northern Ireland, certainly in England and Wales, the scale is greater, and also in Scotland. And you will see the policy reaction to that, which I think is relevant.
So you were taking us to the policy response to the problem?
Yes, I was, yes. So I wanted to take you to the... So I've shown you already in passing on the way through a 2014 Law Commission analysis, which was produced at the same time, just slightly before the Cheshire West judgment, saying, wait and see, we don't think we need a statute definition, we think this can work quite well. The matter came back before the Law Commission again in light of the issues that were arising here, and you'll see that at 6908. So this is the 2018 Law Commission analysis on mental capacity and deprivation of liberty. And it's a long document, I'm not going to take the court through all of this, but if you go to page 6963, significant public consultation about these matters. This is the discussion section, and at 5.36 it records that many consultees were critical of the Cheshire West judgment, and the Law Commission noted certain virtues attaching to it. They have some degree of sympathy. The concerns were raised, difficult to divorce Cheshire West from its resource implications, and that refers to the 2018 figures, which are much lower than the figures we're now talking about, likely only the tip of the iceberg. Some responses called for a statutory definition of deprivation of liberty, which was narrower than that set by the acid test. In our view, this would be misguided. The meaning of deprivation of liberty reflects our ECHR obligation on Article 5, based on Strasbourg case law, and so forth. And they're identifying a problem here. If the bill interpretation was narrower than the Strasbourg test, there would be a gap and a problem, and difficulties would flow from that. Suggestion then is, at the bottom of that paragraph, we consider the best option to continue to tie the definition of deprivation of liberty to the Convention, not least because the definition continues to be subject to considerable evolution in case law. One might have thought that's a point against it, but anyway. Our decision to base the scheme on deprivation rather than wider criteria was finally balanced. We recognise deprivation of liberty is an inevitably imprecise concept. We consider its outlines are now clearer following the decision of the Supreme Court in Cheshire West, and guidance may help. So no recommendation for a statutory definition of deprivation of liberty at that juncture. The issue is then examined by, following the Law Commission, examined by the Joint Committee on Human Rights in 2018. Twice. First, there's a report comes out in June 2018. You'll find that at 7204. 7208 has a general summary. Second paragraph records the scheme is broken. Supreme Court's decision that a person subject to confinement under continued supervision, not free to leave, has resulted in a tenfold increase in the number of DOLS applications, and the pressures are all recorded there. The Law Commission has produced response in the form of further safeguards, liberty protection safeguards, and they're analysing that. At the bottom of that page, you'll see their view was Parliament should provide a statutory definition of what constitutes deprivation of liberty in the case of that category of patients. So the detail of the report, you'll see again some further discussion of the scope of the problem, 7211, paragraphs 4 through to 8. Paragraph 8, consensus the scheme is broken, and as a result, thousands of people are being unlawfully detained. 3 times more people are detained under this provision than under the Mental Health Act. And 70% of applications don't meet the time limit. Paragraph 9, again, notes that the last sentence, far from being used to protect individuals and their rights, are sometimes used to oppress and to force them upon the decisions made by others with reference to their wishes and feelings. That's some evidence they've got. We then discuss the judgment. I won't go through that. And at 7220, they engage again with the idea of having a statutory definition of deprivation of liberty. And there's a useful passage here at the bottom of the page, 38. This is a person called Mark Neary. It's quite a well-known case in this area. There's a High Court judgment that links to this. I'm not sure I'll find it right now, but this is someone whose son was detained, and the father fought a very long battle through the courts in order to retrieve him to his home again. And he gives evidence to the JCHR, and the point ultimately he's making is that his son is back at home in his own place, doing what he wants to do. He's king of his castle, requires support, but he is content. But he says he finds it very difficult to square that with the fact that he is deprived of his liberty. So this is an interesting illustration of the problem. Someone who is extracted from the system by action through the courts, brought back to their own home in a state of contentment, but still considered to be deprived of liberty, subject to doles and all the safeguards. The Neary case is an interesting example of the difficulties that arise here. I wanted to highlight for you paragraph 43, which is an alternative approach to revisiting the interpretation of confinement, would be to reconsider the meaning of valid consent, the second subjective limit of the test, and you'll see some discussion of that. It's arguable to be construed more widely than the current position, which is recognise there are ways in which an individual, while lacking mental capacity, may still be able to, nevertheless be capable of expressing consent to specific care or treatment arrangements. They, in their view at that point, contend Parliament should set out a statutory definition of deprivation, clarifying the application of the acid test, bringing clarity for frontline professionals. They don't quite take the valid consent proposal further, but they return to it again 6 months later. If you go to 7244, you have at this stage JCHR legislative scrutiny of the Mental Capacity Amendment Bill. This is the legislation that's bringing forward a replacement for the doles safeguards. This is intended to bring forward LPS safeguards. So they're looking at this idea, and again, the summary on page 7248 captures that. So Cheshire West, the second paragraph, identifies the problem in terms of scope. The cost of extending the existing scheme to all those caught could cost $2 billion per annum. Government's brought forward the Mental Capacity Amendment Bill in an attempt to resolve the crisis. The bill follows the Law Commission proposals for a scheme of liberty protection safeguards, LPS, but differs from it proposed in a number of respects. They then point back to the earlier report and engage again in an analysis of this from page 7253. Page 7255, there's a more developed analysis of the valid consent approach. So you saw that foreshadowed in the earlier report. And paragraphs 26 and onwards into 7256 address this. You'll see at the top of 7256 the JCHR refers to Míl Haylov's and to the distinction between de jure and de facto ability to give consent. (27) points to the need to obtain evidence of a positive wish. 28 notes that it might be appropriate where there's no coercion, again recalling the Ferrat and Turkey case, which I'd referred to earlier on. 29 refers to Article 12 of the UNCRPD, which was also a feature of, well, 12.4 was a feature of the Mihailov's decision. 31 notes the safeguards concern, which has already been canvassed in discussions earlier today. And then 32, their recommendation, page 7257. We recognise these issues are complex, require considerable expertise. We're mindful of the inherent difficulties. We believe a lack of statutory definition may result in persistent problems with the new scheme. We recommend a workable definition included in the bill. Consider the two approaches discussed above are worthy of parliamentary debate. We suggest the following amendments to ensure the difficult issues given the consideration it deserves. If you look down to Amendment 2, it goes to the valid consent model. particular, subparagraph 3 looks to the cared for person being capable of expressing their wishes and feelings, verbally or otherwise, expressing their persistent contempt of their care and treatment, no coercion being involved. These matters are confirmed in writing by 2 professionals. That's the suggestion from the JCHR. That is not very far away from the code of practice which the Minister has proposed bringing forward in Northern Ireland. It was, or something like it, was taken forward as an amendment by Lord Wolfe, proposed amendment to the bill while it was in travel. And you can see a reference to that in the supplementary bundle, page 1409. This is a Hansard debate.
109, did you say?
It's page 1405 in the supplementary bundle. It's a mental capacity amendment bill, and an amendment is being discussed, which is identified at page 1410. And you'll see about 4 paragraphs up in the bottom, reference to the text of that amendment being people being capable of expressing their wishes and feelings, confirmed in writing by 2 professors. That's a close analogue to what the JCHR have been looking at. It's linked to a statute definition, or amendment to have a statute definition of deprivation of liberty, influenced by the work of the JCHR. You'll see, I won't read all of that, but the position is resolved at 1412. Lord O'Shaughnessy, who's the government minister in the Lords, indicates that they see merit in having the issue defined in statute. Sympathetic to that point of view, about 4 lines down, gives an assurance we intend to bring forward an amendment in the Commons to give effect to a definition. We want to work with all Lords and stakeholders in course of JCR to ensure we can table an effective amendment that achieves our shared aims and gains the level of consensus we all want to achieve. We'll be able to lay at the common stages. So the Lord Wolfe amendment is withdrawn, so the valid consent amendment is withdrawn at that stage, on the expectation that there will be a statutory definition introduced in the bill. That does not come to pass. You'll see they've referenced this in some of the other written cases. I think the suggestion seems to be there's been a rejection of this model by Parliament. We say that's not quite the case at all. So all of this is by way of showing...
Why do you say that's not the case, that it was rejected by Parliament?
Well, it was withdrawn on the expectation that the government were going to bring forward their own amendment addressing the same area. So the government were going to bring forward a statutory definition
Did they?
of deprivation of liberty. They didn't do that. No. So we're no further forward in respect of that, as far as I'm aware. So I take the court through that to show a degree of human rights proofing at the legislative level of the model which the Minister for Northern Ireland has brought forward. We also say that this is not a heretical idea at all, because you already have a very similar formula in the English MCA itself, in the 2005 Act. So if you look to page 740.
This is back to the main bundle.
Main bundle, yes, sorry, Lord. 740. This is Schedule 1A of the MCA 2005, and you'll see, 739, Schedule 1A, persons ineligible be deprived of liberty by this Act, and then there's a table of ineligibility. Don't want to get lost in the detail of this, but I want to take you to paragraph 5 on page 740. The purpose of this paragraph is to determine whether people who are incapacitous should be taken down the DAWLS route, deprivation of liberty safeguards, or should be taken into the Mental Health Act territory and be subject to the safeguards in that area. So we're dealing with...
Where are you reading from?
It's paragraph 5 on page 740, my Lord. So P objects to being a mental health patient, etc. This paragraph applies in cases D and E in the table in paragraph 2 above. P is ineligible if the following conditions are met. So ineligible for deprivation of liberty In other words, you can't be a Dawes case, you have to be into the Mental Health Act. So the conditions are that they object, being a mental health patient, or be given some level of treatment. And then over the page, this is the point I wanted to show you. In determining whether or not P objects to something, regard must be had to all the circumstances, including the following: P's behaviour, and B, P's wishes and feelings. Regard has to be had to all the circumstances and pass only so far as it's still appropriate to have regard to them. This is a primary legislation taking the concept of wishes and feelings and using it as an indicator of whether one type of safeguard or another is applicable to an incapacitous patient. So we say again, proof of concept is not just in the JCHR reports and Lord Wolf's amendment, but also in what Parliament has actually enacted in that part of the MCA. And we say that's, again, supportive of the position that the Minister adopts. If I then could go to...
Someone, because it's making clear that whatever their wishes and feelings are, they're still deprived of their liberty, and so you have to go by one route or the other.
Yes. But it's the utility of that as a tool to determine what consequence flows, we say. Don't put any higher than that. Then let's go to, briefly, to the code, the Northern Ireland Code, which is in its original form found at page 1583. This is the November 2019 code. This comes into force when the Act, or the relevant part of the Act, is commenced. It deals with the issue of deprivation of liberty at page 1592. If you look down to paragraph 2.6, you'll see the test. The test: if a person lacks capacity to deprive their liberty, the following question must be asked: are they under supervision and control? Are they free to leave? That's the end. That is the acid test from Cheshire West. It has no Stork subjective element attached to it.
Because they lack capacity.
Yes. So the code then deals with patients lacking capacity. You'll see it 211 on page 1593. 211. My destination is on the right. Actually, it's down here. If a person no longer has capacity to consent to the arrangement, all the safeguards of the Act must immediately be put in place. So, no capacity, route 1, direct to Dawes and all the safeguards. That's the way in which this code operates. And then they give examples of who may be subject to a deprivation of liberty. I won't go through all of those, but for example, and this is probably unique to Northern Ireland, go over the page 1594, letter H, in a private home where the patient is bedbound, receiving round-the-clock care, but would be prevented from leaving if he or she had the ability to. So reaching right into the private home is a difference from England and Wales, I believe, because if the care is funded through appropriate social security benefits, then that will be considered to be a deprivation of liberty and will engage all the necessary safeguards.
So you're saying in England and Wales that doesn't amount to a deprivation?
I'm not professing to have expertise in England and Wales, but I don't think it stretches beyond or into private home facilities. Is that right? Yeah, it's a court order case, yes. So it's not the same. In Northern Ireland it does.
No, on the contrary. In a private home, as I understand it in England and Wales, you need to get an order of the Court of Protection rather than using you can use a streamlined procedure or not.
Yes.
Whereas the administrative procedure is only for hospitals and care.
That's correct, yes.
I think I've read
So it's a
somewhere
more stringent procedure for a private home than it is for a hospital or care home in England and Wales.
It's certainly different, that's all I can say. But,
isn't there some problem about the Court of Protection procedure? My recollection is, isn't there some issue about local authorities not having the funding to actually make the applications to the Court of Protection?
well, again, I'll defer to Mr. Lockeen on that. I think yes, getting a nod of assent, but I don't know the detail of that.
I mean, it's in theory, it's rather like Dawes. required in theory, but in practice it doesn't happen.
Yeah.
So just before we leave this document, just looking at paragraph 2.11, page 1593, I mean, I think this document is talking about capacity in the full sense, because it seems to be saying they can consent to anything for which you would need full legal capacity in our system.
Classic binary position. If you haven't got capacity, that's it. There's no sort of second order consideration a la Stork subjective test. It's straight into the Dawes arrangement. So then, just to finish on this point, the proposed amendment is at 275. So this is attached to the reference. You have an extract of the revised statutory code. So this is Chapter 2, Deprivation of Liberty, to be compared with the version we just looked at.
Could I have the page again?
275, my lord.
275. Thank you.
So on your screens, this may be coloured, I don't know, but it's there's grey highlighting in paragraph 2.3, which shows the additional text. So if you look to the bottom of 2.275, you'll see 2.6 is the test. So the test, you recall, had only two components before. The acid test was the person under continuous supervision and control. Were they free to leave? The Minister now proposes to add whether the person's expressing consent to the arrangements for their care. The test changes, not pure Cheshire West. If Cheshire West binds in the way that it's contended for, then this addition is problematic. If Cheshire West is a correct interpretation of what Article 5 requires. If in fact Article 5 is to be read in the way which we contend for, then that addition is conceptually appropriate and the Minister has power to make it. If that is right, then the detail that follows at, you'll see 211, this is quite different. I don't know if you can have two versions open at once, but if you compare the original, you'll see this is a complete insertion in respect of consenting. So these patients are to be assessed according to this criteria. So if they do not have the capacity, so 212, but they actively express positive wishes and feelings about the arrangement in place, it's not enough that P does not express objection. There must be evidence of a positive attitude to the care arrangements. For example, and two examples there, they regularly say they like where they live or appear keen to return to their home. In either case, there's no evidence of resistance or objection to the arrangement in place. Then there's an onus on those who are confining that person to explain at all times how they can be regarded as consenting. If they cannot do so, the arrangement will be taken to be a deprivation. That engages the machinery of the Dawes. And then discussion of what happens if someone has capacity and then loses it. So the amendments are, as set out, they are relatively limited, but what they do in our submission is give effect to the subjective element of the Stork test. And the practical consequences can be worked out in due course. If the Minister has the power to make these amendments, it's likely to reduce significantly the categories of individuals who are currently subject to the Dawes safeguards. But we say this does differ from majority in Cheshire West. That's clear. But we say the majority in Cheshire West parted company with the Stork test, and this court, in considering the reference, can realign and ought to realign that analysis.
And from the authorities you've shown us, I think most of them were considered in Cheshire West. So does that mean you are inviting us to apply the 1966 practice statement?
I think almost all of the authorities were considered except a Cervenka case, a 2016 case. I don't think there's anything else that's new. So two ways of looking at the point. Because it's a Section 306 ambulatory requirement, if you like, then this court must give effect to the Article 5 jurisprudence as it is now. It hasn't really changed, but if you have to do it as of today, then that's one way through. If that's not appropriate, then this is a case that directly engages the practice direction.
Right. I mean, this in a sense goes back to the discussion we had
Yes.
right at the start.
Yes, it does.
I mean, I'm not sure, I've forgotten which is the name of the case, Cervenka. Unless we came to the conclusion that it doesn't really look like that changed anything very much in Strasbourg terms. So I'd have thought that Cheshire West is the authoritative determination by this court of what the Strasbourg authorities mean, which seems to drive us towards we would have to apply the 1966 practice statement. Is that right?
I think that's right. Cervenka doesn't really move the dial. It's a repetition of the earlier cases where there was a refusal of consent. So it doesn't change any of the concepts. There isn't a Grand Chamber decision that touches on the issue, save for Ruman, which isn't quite on point. So I'm not suggesting there's been a sea change in the Strasbourg authority. It is probably a case that requires practice direction engagement.
And how would you bring yourself within the practice direction?
I think again,
On what ground?
I think it's what we say is an obvious error in terms of the failure to give effect to the historic subjective element, an essential element according to the Grand Chamber in paragraph 117 of Stanev. So that's the critical fault in the majority raising in Cheshire West. It is a case now of 11 years vintage. It's not a case that was decided last year. We've been over some of this ground in the Dalton case not so long ago. Some considerable time has passed. The consequences are significant. I've shown you statistics from the Department of Health, 23-24. The cost projections are significant. 2.2 billion per annum if it's properly implemented, which it isn't being properly implemented. And the rights implications for individuals are also significant. So this is a case which we say meets many of the criteria for...
That meets the criteria potentially in relation to the subjective element. What do you say about the objective element?
Well, that's not our reference, Lord. I think is what I say about it. We have brought the reference on behalf of the attorney based on the Northern Ireland Minister's proposal. Had he proposed completely remodifying the acid test, then I would have to address that issue. The Secretary of State makes a case about all of that. I don't want to undercut it or to take issue with it, but our submission is that that's not the reference that's before the court. But it's clear to us that there's been a stepping away from the true path in the majority judgment in Cheshire West. And where you part company with the Grand Chamber decision on the essential criteria, bearing in mind the Section 306 obligation of the court to align with the Strasbourg jurisprudence, we say this is a proper case for the engagement of the practice statement.
Well, in the practice statement, the House of Lords said that too rigid adherence to precedent may lead to injustice in a particular case and also unduly restrict the proper development of the law. Do you cite in aid either of those?
Well, the restriction in the development of the law, what you will see, I haven't gone through them, but there are some lower level judgments where efforts have been made to recalibrate. There are several decisions of Justice Mostyn on the point. The reference is going to escape me right now. There's a judgment of Justice Leven, which again, these have proven to be controversial because the judges in question were pushing against the analysis in Cheshire West.
Well, that's at Rochdale and Peterborough.
Yes, exactly. Yeah. That's the case I was thinking of. Yes. And the ultimate answer, there was a fairly firm rebuke by the Court of Appeal to Justice Mostyn that effectively Cheshire West was the law to be applied. That was the end of the matter. And so there is an ossification can occur because we're not getting cases coming through the first tier into the Court of Appeal testing the point. So the scope for a case coming back before this court is very limited. That's reflected in the fact that we're here on an AG's reference. You couldn't bring this point if you were in England and Wales because there isn't a devolution issue. There isn't a devolution issue jurisdiction to bring the point forward. It's only by the devolution mechanisms that apply in Scotland, in Northern Ireland that the issue can come to the fore. So you do have an issue in terms of the ossification of a line of authority that can't be overturned, which is causing real hardship, real difficulty, and that would warrant this court taking the unusual step of engaging the practice direction.
One of the circumstances in which the practice statement can be invoked, I'm looking at a case called Ex Parte Hudson back in 1972, appeal cases 944, and it's Lord Simon of Glaisdale lists various circumstances at 1024, and one of them, he says, is where it, if it were convincingly shown, he's talking about a matter of statutory construction. He says, a variation of view on a matter of statutory construction, so much a matter of impression, would, I should have thought, rarely provide a suitable occasion by itself. For it would be different if it were convincingly shown that a previous construction, clearly demonstrated to be wrong, was causing administrative difficulties. So you would say, I suppose, that this is a question of application of, well, a construction of what's the deprivation of liberty within the meaning of the Northern Irish statute. And you would say the previous construction, you would say, is demonstrated to be wrong and is causing administrative difficulties.
Yes, I should have given you, there's evidential source on that, a point I skipped over in the interest of time. There is a Northern Ireland evidence base for all of that. There's a Commissioner for Old Persons in Northern Ireland. I'll just give you the page reference now. It begins at 8,055.
Sorry, page again?
8055. So it's a very recent report of the Northern Ireland Commissioner, and maybe I should open it.
And sorry, just in a nutshell, what does that show?
What it's showing is a real detrimental impact, particularly among the very elderly. So it's
Among the what?
the very elderly, so advanced dementia type cases, or people who are.
Well, I'm puzzled at that because you showed us the guidance, and at 278, page 278, it seems to not be, as you were suggesting before, situations where P is unable to leave. The person's physical health has deteriorated to the extent that they're unable to leave. It doesn't automatically mean that the person is not free to leave. That question must be answered. If the person could leave, would they be allowed to? If the answer is yes, they're not deprived of their liberty. So that seems to suggest that the person who is unable to form a view and is so ill that they can't actually form that view isn't treated as being deprived of their liberty.
I don't think that's inconsistent with what I've been saying. I mean, the catastrophic dementia case, and there'll be many of those,
Yes.
they'll be outside all of that, but it's the lesser cases, people who are moving towards that direction but aren't there, which are caught by all of that. Sorry, I'm trying to find the relevant page, but the Commissioner for Old Persons evidence is about the onerous nature of the bureaucracy in all of this. The fact that it's not always being done, the fact that it engages medical practitioners, ties them up in performing these tests because every one of them requires a doctor, and the resourcing implications for all of that. Page 8080.
Sorry, say that again.
8080. 8080, my lord. Problems with the scheme are set out there. They find themselves involved in it's the third paragraph.
May I have the page number again?
8080.
8080.
to find it on my feet here, but there's a Northern Ireland-based evidence, a Northern Ireland evidence base for the contention that there's real practical problems. There's probably much more said about the position in England and Wales. The scale is bigger, the numbers are bigger, the absolute numbers are bigger, but the same points read across to our jurisdiction.
Now, you're 10 minutes past your time, Ms. McLean, and I'm afraid we'll have to bring your submissions to an end, and thank you very much. Lord Advocate.
Thank you, my Lord. My Lords, my Ladies, in participating in this reference as a law officer in the public interest, my primary concern is to ensure that, whatever the outcome, the rights of vulnerable individuals who are subject to state measure of confinement are protected by way of appropriate safeguards. I recognise at the outset that the Court is considering a question referred in a statutory context for Northern Ireland, England and Wales, which is quite different to the current statutory regime in Scotland, and that aspects of that regime in Scotland, in particular cases, have recently attracted some criticisms from the Court of Protection here in England and Wales. In relation to the Scottish position, I can explain that there's been some, albeit limited, judicial consideration of the Article 5 ECHR compatibility of the current Scottish arrangements, and we've alerted the Court to this, as noted in the Statement of Facts and Issues at Appendix 2, paragraph 16, that an Article 5 ECH challenge was rejected by the Scottish Sheriff Appeal Court in 2021 in a case JK against Argyll and Bute Council. In that particular case, the Sheriff Appeal Court held that the Adults with Incapacity Scotland Act 2000 provides a comprehensive statutory scheme with multiple safeguards that make deprivation of liberty under a guardianship order lawful and compliant with Article 5. However, there have been two recent decisions of the Court of Protection in England in which the Court refused, on Article 5 grounds, to recognise the particular Scottish guardianship orders which were being relied upon to authorise the deprivation of liberty of a vulnerable adult. And again, reference to these cases are in the Appendix 2, the Statements of Fact and Issues at paragraph 16. I think it's important that I explain that in neither of these cases before the Court of Protection was it contended that the Scottish system itself was inherently incompatible with Article 5. In both cases, it was acknowledged that the limited review which the Court of Protection carries out does not require consideration of whether the Scottish system is systemically defective as a whole. Rather, it was that the Court considered that it should, in each case where an application for recognition is made, consider whether, firstly, the process whereby the order in question was made, and secondly, the effect of that order afforded sufficient protection for the convention rights of the individual. So that said, the Scottish guardianship orders, which the Court of Protection refused to recognise in these cases, were fairly standard. And it's against that background that it's important to note that the Scottish Government has acknowledged, indeed on more than one occasion, that there are shortcomings in the existing statutory framework so far as ECHR compatibility is concerned, and that reform is required. And we've set down in our in the Statement of Facts of Issues some of the background to that, and I can come on and look at that a little later, but I can summarise the position, which is that in response on the 20th of June 2023, the Scottish Mental Health Law Review, known as the Scot Review, the Scottish Government acknowledged the need to update Scotland's mental health and incapacity law if they are to keep pace with the developments in international human rights standards. Similarly, in its response to a consultation on the Adults with Incapacity Scotland Act 2000, which ran between July and October 2024, the Scottish Government accepted that the 2000 Act should be reformed in order to address concerns around whether the Adults with Incapacity Act had indeed kept pace with the developments in human rights law. In September 2024, the Programme for Government included an Adults with Incapacity Bill as a first step to update and modernise the law with the Adults with Incapacity Scotland Act 2000 in line with developing thinking and international standards on human rights. So there is an identifiable need for change, and the government have a good understanding of that, and are seeking to develop reforms in order to bring matters in line with the jurisprudence of the European Court of Human Rights. So my intention in this reference is to address this court in relation to general principles which would apply in any context as set out in the Statement of Facts and Issues. The court's decision in this case will inform the process of law reform which is already underway in Scotland, which will seek to address the criticisms that have been made of the current regime.
Can I ask, Lord Advocate, in relation to those criticisms, do we have the cases cited in the annex in our bundle?
Yes, we do. We do. And I can make sure that you got those tomorrow.
Sorry, just can I ask on that? Was the difficulty about reception of the guardianship orders in England and Wales that they considered that the Scottish courts had not complied with rights under Article 5?
That's correct, in terms of the review process.
Right.
Yeah.
And that's because you have an administrative review process, and after Cheshire West it was left unchanged.
Yes, I think that's the point.
And who made those guardianship orders? Were they orders made by a court, or?
They were orders made by a Scottish court, the Sheriff Court.
I mean, I can see that if the Scottish court has misapplied Article 5, that might create a difficulty. But given that a court itself is bound, subject to primary legislation, to comply with convention rights under Section 6.3 of the Human Rights Act, I'm not sure that those cases in themselves indicate that there's a problem. Obviously, people have to get Article 5 right and apply it right.
Yes. So I think that I did say that earlier on, that there's not been a statement by the Court of Protection that there's a systemic issue with the Scottish procedure.
Right.
And indeed, at Sheriff Court level, at the Sheriff Appeal Court, that very issue was raised in terms of whether or not the process in Scotland was Article 5 compliant. And the Sheriff Appeal Court held that it was. And that material is in the Statement of Facts and Issues, paragraph 18 of the hearing bundle at page 34, and so there's an annex to the Statement of Facts and Issues that sets down the Scottish legislation and makes reference
it's
to
page 35 onwards in the key documents bundle, and paragraph 18 sets out the proposals for reform.
Yes, thank you.
So, safeguards for the most vulnerable people in our society are obviously essential if there is a situation which is a deprivation of liberty, both for the individual detained, whose confinement is then regulated, but also for the persons detaining them, as their actions in doing so are then authorised by law. The central submission which I make on the question referred is that safeguards are also essential if a vulnerable person is to be taken to have consented to confinement, as their situation of confinement, which is not then a deprivation of liberty, will not be regulated, at least for the purposes of and potentially in the manner required by Article 5. Safeguards obviously apply in a different way in each scenario, and regulating the obtaining of consent to confinement in one scenario and the confinement itself in another, but they're equally important, and if they're not adequate, the confinement that follows will be equally arbitrary and unlawful. So it is, I say, a matter for this court if it accepts that valid consent can be given by individuals with impaired decision-making as to what is required.
But could I just understand that last comment? I mean, if it's not deprivation of liberty, what is the illegality in confinement in terms of the convention,
So,
or in terms of a domestic law?
So the confinement itself has to be one that we're looking at a situation where we have people who lack capacity and who are taken to consent to their confinement, and that brings them out of the reach of Article 5. But in order to make that situation lawful, the state has to provide, or those who are providing the care have to ensure that the confinement itself is properly applied to the facts and circumstances of the individual. It would be unlawful for the system that's in place not to meet their particular needs.
Well, perhaps you can, I mean, in a sense you're repeating the point you've just made. I mean, if you can explain to me in the morning in what respect you say it's unlawful or arbitrary if we are outside deprivation of liberty. At the moment, I don't understand that from your case.
I can come back to that tomorrow.
Thank you.
Interested also in what your view is about the acid test.
Yes,
and also whether in circumstances where somebody is completely incapacitated, they can't move, whether that is whether one gets onto the subjective element. Because if they can't literally move, they're not deprived of liberty.
Yes.
They're deprived by virtue of their own.
So I am going to come on and look specifically at the Secretary of State's submissions on the LeMay.
Sorry for interrupting.
Yeah. And I am going to deal with the question of, for example, someone who's in a persistent vegetative state. And I would say that would not be a confinement situation. But there's a difference to be drawn on facts and circumstances and the concrete situation of a patient with perhaps varying degrees of dementia. So every case, as we see from the authorities from Strasbourg, has to turn on its own facts and circumstances. There is perhaps a more philosophical question of what is liberty in certain circumstances. I think that's something the Secretary of State touches on in her written case. So I can explain the arguments I'm going to make in relation to Cheshire West. What time is it? 5 to 4, so that we can leave it there and I can restart tomorrow. In relation to Cheshire West, so I've got 4 arguments and summary in response. The first argument which I'll address is that Cheshire West, the argument I'm addressing is the Secretary of State's argument that Cheshire West was wrongly decided as the test which it formulated went beyond the Strasbourg case law. And the Secretary of State is also understood to be inviting the court to adopt the Engel-Guzzardi multifactorial test in place of the so-called acid test, with a focus on the concrete situation of the individual. That's the Secretary of State's case at paragraph 56, hearing bundle, page 116. My position on the first argument will be that Cheshire West did not depart from the Guzzardi test, but applied it to the concrete situations at hand. And I'm going to argue that in distilling it for the purposes of the cases before it, the majority did not go beyond the principles established in case law.
So I think then on that, you're disagreeing with the submissions that we've heard from
Yes.
Mr. McLennan as well as with the Secretary of State.
I mean, does that mean that I mean, this is something you can discuss tomorrow. Does that mean you're saying that the acid test was only an acid test for MIG and MEG, but wasn't guidance for other purposes?
That's right. So I'm saying that the test
That's not
applied.
normally the practice of the Supreme Court.
Well, I think if we objectively read the decision as a whole, that's what the proper reading of the case is. Or it may just be that the case itself requires to be clarified in any decision from this court.
What do you say the proper reading of Cheshire West is that the acid test only applied to the facts of that case?
To the types of cases
Right.
that Baroness Hale was dealing with, and she specifically opens up the leading judgment by explaining just that very fact, what this case was concerned with. I'll just get the opening paragraph. So she says, this case at paragraph 1, hearing bundle page number 2936, this case is about the criteria for judging whether the living arrangements made for mentally incapacitated person amount to a deprivation of liberty. And she's talking in this case about individuals who are incapacitated by reason of physical and mental difficulties, who were incapable of giving valid consent and who required wraparound care packages. And to their benefit, they were being delivered in the local community.
But are you saying that they were not assuming that because they were assessed as having mental incapacity, that they therefore could not give valid consent?
So the Cheshire West case is proceeded on the basis that at first instance, none of the individuals could give valid consent. I'll be able to take the court to the...
But why couldn't they?
I'll be able to show the court that the rationale for that in the decisions from the court below. I've got the paragraphs for that tomorrow.
Well, perhaps we should allow you to summarise your submissions and then develop them tomorrow.
Yeah. So I'll be able to show that everybody agreed in this case, Cheshire West, for all of the individuals, they couldn't give valid consent. And so the issue of the subjective test of consent was never looked at by the court. I will, however, as I'm going to say, invite the court to clarify the types of cases to which the decision applies, and that there may be circumstances in other types of cases in which the acid test is not the complete answer to the question whether an individual is confined. I've shown the court page 2936 of the types of cases the judgment was concerned with, and I think it's also relevant to highlight paragraph 44, hearing bundle 2950, where it's identified that the particular context in this case was the placement of mentally incapacitated people whose lawful detention in any setting designed for their care is always potentially justifiable under Article 5(1)(e). The second argument which I'll address is that the majority in Cheshire West were wrong to conclude that a lack of objection is never relevant to the question of confinement. And that's the Secretary of State's case paragraph 57, hearing bundle, page 116, on the basis of which the Secretary of State invites this court to confirm that the wishes and feelings of an incapacitated person were relevant to limb A of the Stork test. That's at paragraph 76, hearing bundle, page 122. The suggestion made at paragraphs 4 to 5 of the Secretary of State's case, page 94, that the decision in Cheshire West wrongly eliminated the consideration of coercion from the objective limb is understood to be part of the same argument, and I'll address that in the same section. So my position on the second set of arguments will be that the court in Cheshire West was correct to conclude that a lack of objection is not relevant to an assessment under limb A, and that it would be contrary to principle to take positive wishes and feelings into account at the objective stage of assessing whether there's evidence that a coercive measure was being used, but that the existence of objection as evidence of coercion is undoubtedly relevant. However, I'll ask this court to make that clear.
Relevant to what?
Limb B, presumably.
Limb A.
It is relevant. So I thought you were saying that they were correct about Limb
So I'm
A.
saying expressions of positive wishes and feelings are not taken into account. Compare and contrast that to the existence of someone who is positively pushing back against the regime. That is something that, as evidence of a coercion, would be relevant to the question of limb A.
I see. So positive expressions are irrelevant, but negative expressions are relevant through the avenue of coercion.
Yes, so you're pushing back on what you've got. You're constrained by it.
Do you disagree with the Secretary of State?
Yeah, yes, I do. The third argument, which I will address, is that the logic of the decision of the Court of Appeal in the case of Ferreira applies equally to social care settings. Secretary of State makes that argument at paragraph 39, hearing bundle, page 109. The result, if the Secretary of State's argument on that point were to be accepted, is not set out by the Secretary of State, but it is assumed to be that Cheshire West would, in at least some of the settings, no longer apply. So I will invite the court to conclude that Ferreira was correctly decided. The decision of Lady Justice Arden supports rather than undermines the decision in Cheshire West and its application to social care settings, including the type of settings at issue in that case. And the fourth and final argument, which I will address, is that Article 5 should not be found to apply to own home cases if an individual is living in accordance with their wishes and feelings, unless, the Secretary of State says, far more extensive restrictions apply. The reference point, far more than what, presumably being the restrictions at issue in Cheshire West, and that argument's made by the Secretary of State at paragraph 51, hearing bundle, page 114. The Secretary of State suggests that such restrictions would require, for example, restraint, medication, seclusion, social isolation, no contact with the outside world. That's also at page 114. And I'll invite this court to reject that submission. There's no basis for this in the authorities. It is contrary to principle to apply a heightened test in the own home environment. And the Strasbourg case law supports the conclusion reached in Cheshire West that an individual may be deprived of liberty in their own home, or more properly, given that none of the individuals were in their original homes, a home-like environment. So those are the arguments that I'll be advancing in relation to Cheshire West and the objective test. And in relation to the subjective test, my position is the court never considered that because the issue was not before the court, because of the conclusion that nobody was capable, none of these individuals were capable of giving valid consent.
We will look forward to hearing you further at 10:30 tomorrow morning. In the meantime, the court will adjourn.